Hi, I'm Dan from Blue Acre, and I'd like to talk about what I think is one of the biggest impediments to innovation in the legal industry. I call it the PDF paradigm, and it's basically our obsession as lawyers with generating work product that in the end always looks like paper, right? We start with the electronic text, and then we lock it into a format that makes it dramatically less useful. We do this for contracts, we do it for legal briefs, court opinions, everything, right? The concept of pages and paper is just baked into the way that we think and work as lawyers. And as a result, the way that we interact with the court hasn't changed in over 100 years. That's supposed to say 1901 and now. We just are exchanging these pieces of paper back and forth between the parties and the court. And I say we're paying a big hidden cost as a result of doing business this way. First is a compliance cost, right? We spend, or frankly waste, thousands of hours every year simply doing things like formatting documents, setting the margins, the line height, the typeface, all of that stuff, just to comply with what courts ask us to make documents look like. And by the way, every court has its own set of rules. Another big problem is search. We can't just go to the court's website, type in a couple of keywords, and get a list of results from all of the documents that have ever been filed with the court. It just doesn't work that way, and PDF is part of that problem too, I think. But as a litigator, one of the most frustrating things to me is that our briefs are actually full of links. We call them citations, but they're really just links to other stuff, exhibits, affidavits, cases, statutes, all the things that we think are really important. And yet we make it really difficult. We in fact put the burden on the reader to go out and find these documents. We're giving them dead links effectively. So imagine though if we had a case management system where you could write in plain electronic text and then actually dynamically on the fly create links to all of these documents that we're interested in creating. So instead of saying, C. Smith deposition attached here too at Exhibit E, page 112, line 2, which is how we all do it, we could actually create a link that delivers the reader directly to that point in the deposition, or maybe even better, directly to that point in the deposition video that the reader now viewer can actually just start watching from there. Now, when you're done with this electronic brief, you can just post it to the court via an API. Everybody gets notified. New dates would get calendared automatically. Now, there's some side benefits to this as well. The public would have much better access to our law and to our courts as a result of using a system like this. And we would be able to collect a lot more information about our court system to do the kind of cool, deep analytics that are just not possible or very difficult to do today. Now, why don't we have this? I hope maybe I've convinced you it's a good idea, but we don't have it because most case management systems used by courts simply reinforce the PDF paradigm. They are simply, like if you look at the federal ECF PACER system, that's just a PDF uploading system that was developed in the late 1990s, and you have a lot of state and municipal courts that are just trying to emulate that. But if we look at other industries that have been very committed to paper, we see that they not only innovated out of it, they actually transformed their entire industry when they did so. A good example of this, maybe an obvious example of this, would be the newspaper industry or the news publishing industry. The way we read the newspaper today is fundamentally different than the way people read it 100 years ago. We have navigation, we can read it on multiple devices, we can search, we can link to other audio, video, content, etc. It's much better. Likewise, the way that we shop. We didn't just turn the mail order catalog into a PDF and call it a day. We actually changed the entire experience for everybody. We use the same technologies: search, linking, automation, integration, right? But what I want to point out is that the explosion of e-commerce and e-publishing that we enjoy and see today was benefited greatly by the development of a couple of key free open source applications like WordPress, Drupal, Magento for e-commerce, and a couple of others, it meant you didn't have to start a store from scratch if you wanted to start an online store or a blog. But our courts don't have applications like that to start off with. If they want a new case management system, they have to either go out and build it themselves or go into the market, and it's extremely expensive, and there's not a lot of time, money, or opportunity left to innovate with new ideas. Now, there's a lot of people who are working on different parts of this problem. The legal citation part of it. At Blue Acre, we're doing stuff with PDFs and so forth. But, I think it's time we start bringing all of these ideas together into a single, unified, and working platform. I call this idea a WordPress for courts, a free, open-source case management system that could be installed by any court in the country easily and cost-effectively. So instead of having vendors being sole source providers of a proprietary solution, they would become the implementers and the augmenters of a simple, standardized solution. A solution that, by the way, would solve the problem of access and search and links, and that ultimately would help us get to a better place. Now, I think personally that this is an ambitious goal, obviously, but look, I don't think it's a technology problem. I think, in fact, the technology may turn out to be the easy part. We are the hard part as lawyers, but if we don't want to be in the PDF paradigm 15 years from now, we actually have to get started today. Thanks.